And judges may begin.
Great, thank you so much, and congratulations for making it to the national finals. My name is Jamie Gass. I'm director of the Center for School Reform at Pioneer Institute. It's a Boston-based think tank that does research on K-12 education reform.
Hello, everyone. My name is Darcy Kern. I am a professor of history at Southern Connecticut State University and also an alumna of the program. So I've been where you are, and we're looking forward to hearing from you.
Good morning. My name is Tim Isaacs. I'm executive director for the Center for Teaching the Rule of Law at Roanoke College in Salem, Virginia. And congratulations on being here today as finalists. Good luck.
Maybe you could introduce yourselves and your teacher.
Hi, my name is Taylor Shank, and I'm a senior at Boonsboro High School. And next year I will be attending Virginia Tech to major in architecture.
Good morning. My name is Rebecca Ropka. I'm also a senior at Boonsboro High School, and next year I'll be attending Penn State to major in international politics.
Hello, my name is Lindsay Sparkman. I'm also a senior at Boonsboro High School, and next year I'll be attending the University of Maryland and studying environmental science and policy. And this is our teacher, Mrs. Vasic.
Good morning. I have a former We the People student coming to Roanoke next year, so that's awesome to hear.
Great. Well, thank you so much for all your hard work. So this is Unit 1. We're going to be addressing question 2. I'll read all of the Unit 1 question, all of question 2. So Unit 1, what are the philosophical and historical foundations of the American political system? This is question 2. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Timer? You may.
Habeas corpus first originated back in 1215 through the 39th clause of the Magna Carta signed by King John.
The concept originally found its way into law in 17th century England, and Catholics are considered disloyal to the throne of King Charles II. Catholics, therefore, could be imprisoned as a result of their religious allegiances.
The Habeas Corpus Act of 1679 made consistent a number of previous habeas corpus acts and confirmed the right of British subjects to apply for a legal document called a writ of habeas corpus.
A writ of habeas corpus orders an official to deliver a person who is in custody to a court of law to explain why the person is being held. If the government cannot justify keeping the individual in custody, then the person must be set free.
It is stated in Article 1, Section 9, Clause 2 of the U.S. Constitution that the privilege of the right of habeas corpus shall not be suspended, unless when cases of rebellion or invasion the public safety may require it.
The writ of habeas corpus is one of the most important limitations on government power, because it means that no government official can hold someone in prison arbitrarily or indefinitely.
The writ of habeas corpus primarily acts as a writ of inquiry, issued to test the reasons or grounds for restraint and detention. The writ thus stands as a safeguard against the imprisonment of those held in violation of the law by ordering the responsible enforcement authorities to provide valid reasons for detention.
As a fundamental instrument for safeguarding individuals' freedom against arbitrary and lawless state action, the writ of habeas corpus serves as a procedural device by which executive, judicial, or other governmental restraints on personal liberty are subjected to judicial scrutiny.
The law of habeas corpus was adopted in the U.S. by the early founding fathers. In 1789, James Madison argued for the adoption of the Bill of Rights, including habeas corpus.
The first Judiciary Act of 1789, Congress explicitly authorized the federal courts to grant habeas relief to federal prisoners. Congress then expanded the writ following the Civil War, allowing for habeas relief to state prisoners if they were held in custody in violation of federal law.
Post-World War II reforms further expanded the writ through incorporation. It became a tool by which criminal defendants sought to uphold their civil rights against illegal state actions.
The Detainee Treatment Act of 2005 and the Military Commissions Act of 2006 further narrowed the scope of habeas relief, providing that prisoners held in Guantanamo Bay may not access the federal courts through habeas corpus.
In the 2008 Supreme Court case Boumediene v. Bush, however, the Supreme Court expanded the territorial reach of habeas corpus, ruling that the suspension clause affirmatively guaranteed the right to habeas review.
Today, habeas corpus is mainly used as a post-convention remedy for state or federal prisoners who challenge the legality of the application of federal laws that were used in the judicial proceedings that resulted in their detention.
Other uses of habeas corpus include immigration or deportation cases and matters concerning military detentions, court proceedings before military commissions, and convictions in military courts.
Finally, habeas corpus is used to determine preliminary matters in criminal cases, such as an adequate basis for detention, removal to another federal district court, the denial of bail or parole, a claim of double jeopardy, the failure to provide for a speedy trial or hearing, and the legality of extradition to a foreign country.
In some circumstances, the writ of habeas corpus can place an unreasonable burden upon the government.
This is because with the suspension of habeas corpus, there comes the issue of burden of proof, as well as a specific set of protocols to be followed.
Under the principle of the burden of proof, there must be found substantial evidence to justify suspending the writ, an issue that historically brought President Lincoln under fire during the beginning of the Civil War.
This motion has since been seen as unconstitutional, seeing as it is not within the president's power to suspend habeas corpus, but is an action specifically allocated to Congress.
Similarly, the internment of Japanese Americans during World War II was made legal through the suspension of habeas corpus that was later ruled to be discriminatory and resulted in $20,000 worth of compensation to be paid to those who were interned.
As such, the suspension of the writ has in fact placed burdens upon the U.S. government that were easily avoidable by finding other means by which to deal with these situations on a case-by-case basis rather than leaping to the nuclear option.
Thank you for listening to our testimony. We're now ready for your questions.
Great, thank you so much for that. The revolutionary and founding generations were raised as British subjects and educated under English law. Could you talk about some of the ways that British law shaped the framers' understanding of constitutionalism?
Primarily, we did get a lot of our ideas about how court trials and hearings are supposed to go. We got a lot of our ideas about due process from the British Bill of Rights. And of course, habeas corpus was something that we got from them as well.
We also got the idea of English common law, which is making precedents for legal situations based on court cases instead of, putting that into place through legislative means. So that was an idea that we heavily borrowed and used in our court system, because instead of relying upon legislation or policy, we use a lot of Supreme Court case precedents as ways to determine policy and how certain situations unfold and the legality of certain things in our country.
I also believe that just from our experience of being under British rule, we got a lot of what we didn't want to see within our country. For example, we knew that we did not want a monarchy or an absolute power as the leader head of our country. So we tried to steer very clear from that with the Articles of Confederation and giving more to state power rather than federal power.
On that issue of state power, and you mentioned state prisoners in your speech, how are state governments impacted by the habeas corpus requirement?
So through incorporation, the right of habeas review has made its way to all states, including the territories that are bound by the U.S. Constitution. So essentially, if a state or a territory of the United States is bound under the code of the U.S. Constitution in any way, with the exception of Guantanamo Bay, then, they have essentially this moral obligation to give this right to their citizens and to review any, files for habeas review.
Also, through the Habeas Corpus Act of 1867, it was granted to the state courts that they could issue habeas corpus in all cases.
You began your presentation by talking about the origins of habeas corpus in Magna Carta. You've also talked about some of the other British legal sources of the American Constitution. At the heart of Magna Carta is a concept which has a direct bearing on the government's use of habeas corpus. It's a concept which goes all the way back to the ancients in Greece and Rome, to the Middle Ages, and it's very much in the news today. Want to hazard a guess as to what that concept is and why it is so important, not just to the British Constitution, but at least in two very specific ways to the creation of the American Constitution?
I'm going to take a guess and say that you're probably looking for the rule of law in this one.
Very good. How so?
Well, if I'm not mistaken, the Magna Carta is, famous for this concept because their whole point in writing the Magna Carta was that they didn't want the king to be above any citizens in England at the time because they were sick of having that single entity ruler who could just do whatever they wanted at, whenever they wanted to. And, that is something that we're definitely seeing a lot of issues with today, especially here in the United States recently in the past 4 years specifically. We had a lot of issues where the president had really just a blatant disregard for the rule of law. And so, the Magna Carta, that was something that really was the primary reason for its existence. And that was something that we supposedly were supposed to borrow from that. And it was supposed to be ingrained into our US Constitution. But I think that recently a lot of politicians have kind of thrown it to the wayside.
So the follow-up to that is then what specific, you talked about being bound by the law. That is in fact one of the principles embedded in rule of law. Are there other principles embedded in the rule of law that have a direct bearing on habeas corpus? Because you have mentioned it in your discussion. Okay, I'll let you off the hook. It's the idea of limited government and what government can and cannot do in terms of its citizens, protection of citizens' rights. The other one,
I think Jamie has a question.
Yeah, I got a quick question to see if I can get it. James Madison is the father of the Constitution, president during the War of 1812. New Englanders threatened a secession, and the British even burned the White House. Still, Madison never suspended habeas corpus and showed great restraint during wartime. Why do you think he did that?
I think he chose to do that because if he had decided to suspend the writ of habeas corpus, it could have put other rights in jeopardy and perhaps set a precedent for leaders, especially presidents, to undermine that in any situation where they think that there could be a threat that would directly cause harm to them or the state. And so I think that by choosing not to do that, it showed great respect for the rights that he had put in place in the Bill of Rights and an understanding that if a leader decided to disregard those rights in any way, it could set a precedent for that being the norm. And he really wanted to avoid that and avoid becoming like Britain.
I agree with my colleague. I think that a lot of his reasoning for doing it goes back to this idea that during the time of the initial founding fathers and when we're sitting down and we're talking about forming America and the Constitution and everything, there was this idea that leadership was supposed to be for like the good of the people and that like leaders had a moral obligation to put the people first, that idea of, like the common good. And so I think that James Madison was really just, as Lindsay had said, taking into account what it might set for future president and how it might affect the citizens of the country.
I agree with both of my colleagues, and I think that if President Madison had done that, then it would have been a slippery slope for the rest of the presidents. And if it had continued in that way and in that manner, then many minor invasions may have been considered reason to suspend habeas corpus, and it could have just led to a slippery slope. So for that reason, I think he chose to refrain from doing that.
Quickly, can the government ever try someone in absentia? Oh, saved by the sign.
Well, thank you so much. As I say to all teams, I really want to thank you and your teammates and your teacher and your parents for all your hard work. This is a very difficult question, I have to say, and I have to say also that I think that you've handled it as well or better than any team that we've seen thus far today. I thought that your introductory remarks were very solid, and the way in which you kind of hit the high notes of British law and some of the foundations for it. I thought that you were very, very strong in tying it to the historical examples that I think really help buttress the argument. I really like the way in which you answered my two questions, the one about British law. It was excellent. Not only did you give examples of positive things that the founders drew from British law, but you also were very clear about the anti-models too. And I think that that was very effective. I thought that the way in which you answered the questions related to the states and the territories was really good, in particular tying the habeas corpus in 1869 to the state courts. That was, I thought, excellent. And I thought that your rationale around and very clear articulation that Madison was trying to make sure that a bad precedent wasn't set, particularly as the author of the author of the Bill of Rights and the father of the Constitution, that slippery slope that you mentioned was an important one for him personally, because he had been such a a central figure in the Constitution itself. So you should be very happy. I think it was an excellent performance.
Yeah, this was excellent. You guys gave the best definition of the writ of habeas corpus that we have seen in your opening statement. That was such a good definition of the writ of habeas corpus. Start to finish. That was a great opening. And I thought in the follow-up questions, you guys did a great job as well. It's particularly